yes, the DMA, it's a regulation. It's a European regulation, so it's directly enforced by the European Commission, but we will discuss that actually the National Competition Authority also support the Commission in the enforcement of this regulation if they have any quite important role to play. Let's now start. So I would like first to discuss with you why we are moving, at least in Europe, from competition policy to sector regulation of digital platforms, the reasons. Then I will provide you an overview with the legal framework at the core of the DMA, and then we will briefly discuss some recent enforcement trends. So this is the starting point of the discussion, because after the coffee break, Nicolò will, let's say, dig into the DMA obligations, specifically those on dealing with interoperability obligation, data sharing, and so on. And don't forget that tomorrow we have a conference, our autumn conference, where we will discuss essentially 3 topics related to the current enforcement of the DMA, so the designation of the gatekeepers, then the meta case involving breach of Article 5.2, and the App Store cases involving Apple primarily, but also Google to a certain extent. Okay, let's start. So this is probably a familiar picture with you. I think you discussed it already with Pierluigi and Nicolò. What is a gatekeeper? An online platform is a sort of meeting point where different players, business users like merchants, publishers, advertisers, get together. It's the point of contact with the end users, the final consumers. Clearly, the gatekeepers have a very strong market power because they control the rule of the games. So there are different forms of competitive dynamics in the context of online platform. We can have competition between different gatekeepers, so inter-platform competition, but we can also have competition within the platform. Very often, the platform provides services in competition with the business users that also rely on the platforms. So this, let's say, special role that the platform has within its own ecosystem creates essentially 2 problems. One problem of sort of contestability, so competition, let's say, with other players. And the second problem is fairness, so the ability of the platform to impose contractual conditions on final users, so also business users, which are considered unfair. What are the peculiarities of digital markets? So essentially, in digital markets, we have competition for the markets. If you are, I don't know, the new, I would say, Facebook back in 2005, 6, you know, you come out with a new invention that radically provides new services in the market, you take the market, you completely take the market, okay? So it's very different in comparison to other markets where we have the idea of market share. So we have a sort of idea of having multiple players in the market that compete with each other. Here, very often, we have de facto single monopolist, okay? We have extreme returns of scale, so the marginal cost to provide an additional digital service to one additional user, it's close to 0, okay? So de facto, when you provide a new service, a new digital service, this service is successful, it's innovative, and you have already a very large user base, it's very easy for you to upscale. And this clearly, it's an entry barrier for new players in the market. There are strong direct and indirect network effects. I think you discussed this issue with Nicolò and Pierluigi when you talk about multi-sided markets. Data are important. Very often we somehow pay as users the digital service by sharing our personal data or by watching target advertising. But actually, we pay with our data, with our attention. Data is non-rivalrous. but at the same time, so there are limits to our ability as consumers to share the data with multiple platforms, technical limits, but also limits in how many digital services, how many platforms we want to use. We want to have 2, 3 social networks. We don't want to have 20, okay? So these are all factors that from an economic point of view lead the platform to tip the market. So very often we had in the last years cases of abuse of dominant position involving digital platforms because of the peculiarities that I discussed before, okay? I don't want to go into these cases. We already discussed some of them during the second day of the class together with Anna Pizarkiewicz. These cases have some peculiarities in common. So the subject of this investigation are the usual suspects, the GAFAM. We have parallel investigations, at least in Europe, by the European Commission and by the large National Competition Authority from France, Italy, Germany, and also from the United Kingdom. We have traditional abuses, time practices, like think about the Google Android that Anna discussed on Tuesday. But we have also new theories of harm, a new type of exclusionary practices. Think about the Google Shopping case, the idea of self-referencing that, again, Anna discussed on Tuesday. We had limited judicial review so far. Why? Because these cases are relatively new, and it takes a lot of time before a competition authority adopts a decision, and the decision is appealed to court. Think about the Google Shopping case, where the Commission started the investigation back in 2010, and only very recently, 1 month ago, we had the final ruling of the Court of Justice, which confirmed the Commission decision. So, because of this ongoing investigation, because of the peculiarities of digital markets that I discussed before, we have seen a sort of shift from a policy perspective in the last at least 5 years, from the idea that we should enforce competition policy in digital markets to the idea that we need sector regulation. Why? First of all, because there is a sort of general understanding, and we can discuss if this general understanding makes sense, that competition policy in digital markets does not have sufficient deterrent effect. So if you take the 3 Google decisions adopted by the Commission, overall the Commission imposed a fine approximately 6 billion euros, which is huge. It's the highest fine ever imposed in the history of antitrust. But we are talking about probably 5%, even less of the global turnover of Google per year. Okay, so clearly Google is extremely reluctant to change its behavior because of fines imposed by the competition authority. They are not effective. There is no deterrent effect. And what I already mentioned, these lengthy proceedings, especially lengthy judicial reviews. Think about the Google Shopping case, think about the Intel case that also Anna discussed on Tuesday. Investigation started in the year 2000, if I'm not mistaken. Now, after the last ruling of the General Court last year, the Commission adopted a new Commission decision, which will be appealed to the General Court and the Court of Justice. So we are talking about a quarter of a century legal saga. At the same time, there are also some political reasons for this policy shift. So when we talk about the DMA, there is also the idea of having a single regulation that harmonizes the regulatory attempts by the different member states. And we will discuss whether and to what extent the DMA was successful to achieve this objective. So the idea is that the EU decision maker does not want the member states to get into this business, let's say. Let's delegate the Commission in Brussels to take care of the GAFAM. And at the same time, a second political reasons, at least in my perception, but clearly something that is not mentioned anywhere, it's probably that there is a sort of perception, at least in Europe, that Europe lags behind when it comes to innovation in comparison to United States and China. It's clear in the last Draghi report published in September, and to some extent, if you impose an asymmetric regulation, which essentially targets US firms, because that's what we are talking about, then hopefully you will encourage the entry of small European platforms. What is exactly sector regulation? I think most of you are familiar with the idea, at least those of you who come from Europe. So in Europe, when we talk about sector regulation, we essentially talk about the network industry. So electricity, gas, railways, postal sector, which have been liberalized back in the 1980s, but also the state-owned company has been privatized, but clearly it has remained incumbent on the market. So at EU level, we had several directives implemented at the national level where essentially the regulators impose ex-ante obligation on the incumbent. So it's an example of asymmetric regulation to foster competition in the market, a regulation administered, managed by national regulators. And we see that there are a lot of similarities with the idea behind the DMA, which also impose ex-ante obligation on the digital gatekeepers, which is also an asymmetric regulation that only targets certain firms that fulfill certain thresholds, and therefore they are qualified as incumbent in the market. So at least this is a sort of source of inspiration. I conclude with this introduction with a sort of picture about what is going on. So essentially at the moment, and then those of you who are coming outside of Europe, maybe you will tell me this slide is not updated. We have other initiatives outside of Europe. But let's say at the moment we have an example of sector regulation of digital platform, the new Section 19A, which was adopted by the German Parliament in January 2021, which is enforced by the Bundeskartellamt, the German competition authority. So it's part of the competition law, but its way of working, it's very similar to the DMA. Also, the type of prohibition, the Section 19A talks about prohibition, not about obligation, but they are very similar in terms of content. Then we have the DMA that entered into force in November 2022, and now it's in full speed, its enforcement. We have the recent adoption of the Digital Markets and Competition Consumer Bill in the United Kingdom, very recent, May 2024, so it's still basically not enforced, this regulation. And finally, we have one legislative proposal pending at the US Congress already for several years. It seems there is no sufficient majority in the Congress to support this legislation. We will see what will happen in a couple of weeks after the presidential elections. So, to break the ice, I have a question for you. What is, in your view, the main reason for the adoption of the DMA? So, do you think the main reasons was, at least from a political point of view, the fact that the antitrust enforcement is too slow? Antitrust sanctions are not efficient, are not deterrent enough, or the DMA prevents legislative initiatives by the member states, or there are some industrial policy consideration behind, like Europe is afraid that is lagging behind the United States and China in terms of innovation. Unfortunately, the European Parliament and the Council are not as fast as the German Parliament, and I would say the Section 19A is in force, and is actually enforced actively by the Bundeskartellamt. So there is this full discussion about how to apply the two legislations in parallel. Essentially, it can take place in two ways. So one way is that the Bundeskartellamt sanctions prohibition under Section 19A carried out by platforms which are not designated as gatekeepers under the DMA. For instance, in areas in core platform services that don't fall under the scope of the DMA, or because a gatekeeper does not have a gatekeeper status in a specific core platform services. We will come back to that. So in that case, the Bundeskartellamt can intervene. Or in case the Bundeskartellamt sanctions conducts which don't fall under the DMA obligations. So in any case, we are talking about a national legislation that broadens the scope of the DMA. Okay, in any case, otherwise it will be incompatible because the DMA is a EU regulation, it's a federal law that prevails over national law. So clearly, what we can say is that the DMA did not lead the German parliament to withdraw Section 19A, which is effectively enforced, but prevented, to a certain extent, other member states to adopt their national regulation. Last point, industrial policy consideration. Very good. Let's now move on to the legal framework. So the DMA aims at basically two main objectives to safeguard contestability and fairness in digital markets. So contestability refers to the ability of the undertakings to effectively overcome entry barriers. So the idea is that a platform is so large that is not possible for other platforms to enter into the market, or this contestability can also be intended platform to be business users, let's say, that rely, let's say, on the platform to provide the services. But the DMA also refers to fairness mostly in terms of the relationship between the platform and the business users rather than final consumers. So the DMA is not in itself an instrument of consumer law protection, but mostly an instrument to protect merchants, advertisers, publishers that rely on large platforms, let's say. Very interesting, clearly, you don't find in the DMA, in the 50 pages of the DMA, any reference to consumer welfare, okay? And this lead, at least in theory, then we'll know in practice what the Court of Justice will say. The DMA say competition law and the DMA can be applied in parallel because they pursue different objectives. So even though we are talking about the different companies subject to the two sets of obligations, the two sets of rules, even though, as I will discuss, the DMA obligation comes from previous antitrust decisions, but the objectives are different. And therefore, we don't have a breach of the so-called ne bis in idem. At least this is what the DMA preamble say. What are the gatekeepers? The gatekeepers, as I told you before, essentially are the platform that controls the rules of the game within their ecosystem. So the DMA is an asymmetric regulation that is applicable only to large platforms, defined as digital gatekeepers under Article 3 as platforms that provide core platform services. They have a significant impact on the EU internal market. They are important gateways, and they have this entrenched and durable position. And a novelty of the DMA in comparison to competition law investigation is that we don't have the classical definition of the relevant market and then calculation of the market share, assessment of the market power, dominant position. But if a platform is active in one of these services mentioned in the legislation, these are 10, online intermediation services like what is provided by Amazon, for instance, search engines, think about Google, social networking, think about X rather than Facebook, video sharing, YouTube, and so on and so forth. And the platform also fulfills those thresholds in terms of number of users per year, both final users and business users. And this position is somehow stable, so it has to be kept for at least 3 consecutive years. Then we have a rebuttable presumption that the platform is a gatekeeper. So it's up, in that case, to the platform to say to the Commission, look, I have a large number of users in Europe. I have a large turnover above the level of the DMA, but I'm actually a sort of new entrance in the market. This is the reasoning that, for instance, X, the former Twitter, has argued with the Commission, and if I'm not wrong, yesterday the Commission published a press release accepting, let's say, the argument by X and decided that X is not a gatekeeper for the scope of application of the DMA. Why? Because we have other social networks in Europe which have a larger number of users in comparison to X, and clearly, since, at least in Europe, since the move from Twitter to X, the number of users of the platform decreased substantially. So it's not considered a gatekeeper. Clearly, it's a very high burden of proof, which is inverted in comparison to the burden of proof that we have in dominant cases, where it's for the competition authority to define the relevant market and then prove the dominance, the market power. Here is the other way around. We have a presumption, a general definition in Article 3, paragraph 1, and then in Article 3 we have these quantitative thresholds, which so far they have been somehow followed by the Commission, but we saw several cases where to some extent the platform has managed to reverse this burden of proof. Yes, indeed. So let's now move to the obligation for gatekeepers under the DMA. I will not spend a lot of time on the obligation because after the coffee break, Nicolo will go into the details of the obligation, at least some of them, the most interesting one. I will just discuss the categories of obligation rather than going into each of them individually. So essentially, we have under the DMA two broad groups, okay? The genus was Anna calling it on Tuesday. So the so-called behavioral obligations, the most important one are in Article 5 and 6, which basically tell to the gatekeepers what to do and also what don't do, okay? So the negative obligations are very close to what we could define prohibition under an abuse of dominance case. We also have, under Article 7, which is a provision added by the European Parliament during the legislative process of the DMA adoption, we have special obligation for independent interpersonal communication services to allow the interoperability, for instance, between WhatsApp and Viber, so different, let's say, communication platform providing communication services. This is a sort of ad hoc provision, I would say, also requires a sort of progressive timeline of implementation. It's very complicated from a technical point of view, and it stands on its own as an obligation in comparison to the list of obligations that we have in Article 5 and 6. Then we also have the sort of compliance obligation. So the gatekeepers are required to appoint a sort of compliance unit, somebody within the company who checks the internal compliance with the DMA obligation. They are required to inform the Commission, to inform about new concentrations, so any new acquisitions of companies independently by the turnover of the acquired company has to be communicated to the Commission. Formally, this is not a notification under the mergers control regulation, let's say. It's just a duty of information. That what is not clear at the moment is what the Commission will do when receive this type of information, also because of the recent Illumina Grail judgment. But I don't want to go into that, and in any case, this is a topic that we'll discuss then in March and April in the course about mergers control in digital markets. Then we have, when we talk about specifically Article 5 and Article 6, different type of obligations. So there is one distinction between the so-called positive obligation, which are the same like in sector regulation, applicable in network industries. So the DMA, via the Commission, tells to the gatekeeper what you have to do now in the market, okay? For instance, don't tie together different core platform services, okay? No, sorry. No, this is completely wrong. This is a negative obligation. So, for instance, ensure interoperability between your services and those provided by third parties. That's something that Niccolo will discuss later. Or we also have traditional negative obligations, which are very close to prohibition under antitrust law. Then another way to differentiate the obligations under Article 5 and 6 is the addressees of the obligation. So some of them, to some extent, concern all users in terms of beneficiaries. For instance, there is a general, let's say, obligation under Article 5.6, which prohibits the gatekeeper to introduce non-challenge clauses in their contractual terms with third parties. So non-challenge clauses are those clauses which prohibit the third party from challenging the validity of the contract or the contractual conditions in court. So this is applicable vis-à-vis all the parties with whom the gatekeeper concludes a contract within clearly the core platform services. Then we have a specific obligation that affects end users, final consumers. There are very few. For instance, there is an obligation under Article 5.5 that strengthens the so-called data portability right under Article 20 of the GDPR. So the idea that end users can, in real time, ask the gatekeeper to transfer their personal data from one platform to another. Clearly, this creates a lot of interoperability issues, let's say, but at least this obligation stays. We also have obligation that benefits primarily business users. There are several obligations that benefits, for instance, publishers, advertisers that rely on Meta rather than Google to advertise their products, and they have been affected by a lack of transparency from the side of the platforms on the terms and conditions. So these are now, let's say, I would say, more transparent than in the past. And then we also have what I was mentioning before, this compliance duties, obligation of the gatekeeper versus the commission, so like reporting about new concentration and so on. Another distinction, which to me is a very fictitious distinction introduced by the Commission, is between the obligations which are self-executing under Article 5. They are directly applicable when the gatekeeper is designated, let's say, and those ones where the Commission can provide further guidance to the parties, but it may provide, is not forced to provide. And this fall under Article 6 and also under Article 7. Also, from a temporal point of view, some obligations, especially those ones in terms of compliance, reporting, take place or start to be applicable immediately when the gatekeeper is designated. Others, like those ones, the most important one under Article 5 and 6, starts to be applicable 6 months after the gatekeeper is designated. Finally, those ones under Article 7, the interoperability or interpersonal communication services, the most complex one, are applicable after 4 years. So let me now, is there any questions about the obligations? Philip, you raised the hand or no? Okay, okay. Any questions, any comments about this distinction between different type of obligations, about the definition of gatekeeper? We will also have tomorrow in the morning, the first panel will discuss the Commission designation decision. So it will be interesting to see what the panelists will say about the recent decision. Then about the, let's say, rules of enforcement. So the Commission has several powers, which essentially mirror the powers of investigation that the Commission has under Regulation 1/2003. Also very similar to the powers that traditionally national competition have and national competition authority have at the national level. So it can send a request of information, conduct interviews, inspections, or down rates. It can also, it has to conduct a market investigation in specific cases, for instance, when a gatekeeper challenge the designation, let's say, a platform say, I notify, but I don't agree. I want to rebut the presumption of being a gatekeeper when there is systematic non-compliance with the obligation or when the Commission wants to update the obligation. Then what about the remedies? You remember that one of the reasons, and at least most of you, if I'm not mistaken, said why the DMA was adopted, because the DMA does not have sufficient deterrent effect, the competition law does not have sufficient deterrent effect. So what about then the sanctions? So, well, actually, when you read the DMA, personally, I get a bit, I would say, disappointed when it comes to sanctions. Why? Because we have huge fines. There is a new fine introduced by the Parliament during the legislative process, which lead the Commission to impose a fine up to 20% of the gatekeeper turnover, which is higher than the 10% that usually you have in competition law. But this is only for serious non-compliance of the DMA obligation. And this expression, serious non-compliance, is not clearly defined under the DMA. So what does it mean? Is a single non-compliance with the DMA obligation sufficiently serious? Or we need to have a repeated number of decisions by the Commission to lead the Commission to say we have a serious non-compliance? This is not clear. So I don't know to what extent the Commission will rely on this huge fine.
Mark, I think Apple is listening to us.
Okay, so you are very interesting. Then what about remedies? So the DMA talks about the possibility for the Commission to impose structural and behavioral remedies, as the competition authority can do, let's say, under competition law, but only in case the Commission has adopted 3 non-compliance decisions in the last 8 years. So what does it mean? In the last 8 years, from the moment in which the gatekeeper is designated. So the first 6 gatekeepers were designated in September 2023. So 2023 plus 8 means that before September 2031, the Commission will not be able to impose any structural behavioral remedies. By 2031, I really hope that the market will change. Generative AI will change the competitive landscape, hopefully. And as a matter of fact, the Commission will never impose any structural remedy, will not split Google in pieces. That's up to the Americans, will not be the Europeans to do it, okay? So this is what I wanted to say, and then I would like also to hear your view about that, is that essentially the DMA impose obligations, let's say, very similar to what we have in sector regulation, in network industries, but as a matter of fact, we will not have a radical change of the structure of the market because of the DMA, okay? It's more like regulating existing gatekeepers and their behavior in the market. Do you agree with this view, or you have a different view about these remedies? What do you think? If I need to make a comparison now with competition law, probably the DMA is closer to mergers control, where you have a system of notification, and most of the times then you have, in that case, negotiated remedies, commitments on the side of the parties. Indeed, these fines are for non-compliance vis-a-vis obligation, but you expect that the gatekeeper complies with the obligation. So we will see, let's say, it's very early to say if the obligation will have an impact or not on the market. Then, interesting for those of you coming from national competition authorities in Europe is the relationship between the DMA and national law. So as I told you before, the DMA is a regulation, so it's a sort of federal law, directly applicable in all the member states, and it leads to sort of full harmonization. But there are several exceptions. So first of all, it's possible for, let's say, for the member states to adopt a specific regulation falling outside the scope of the DMA. It's possible, and I think what is the most relevant case, it's point B. So it's possible to apply in parallel national convention law in addition to the DMA. Why? Because, as I told you before, the DMA has the objective of ensuring contestability and fairness in digital markets. Competition law, it's difficult to say what is the objective of competition law. It can be consumer welfare protection or more generally safeguarding undistorted competition in the market. So it might be that we will have the two systems to come together, multiple sanctions. I don't know if then from a policy point of view, the Commission will opt for this type of solution because it would be extremely risky. This would require the Commission to go to the Court of Luxembourg, and clearly the gatekeeper will challenge this understanding in the DMA, saying we actually have two legislations which are very close, so we have the breach of the ne bis in idem. But at least on paper, at the moment, the two things can be applied in parallel. Then, as Sonia was mentioning before, the National Competition Authority are actually actively engaged in the DMA enforcement. So there are things that the Commission does alone. For instance, the designation of gatekeepers, it's an exclusive business for the Commission. That's where the national competition authorities are not involved. National competition authority can support the Commission in, for instance, down rates, in investigations about non-compliance with the DMA obligations. And then we have this interesting provision, Article 38, paragraph 7, that allows member states to adopt under national law powers for the National Competition Authority to sanction breaches of the DMA. So this is under national law, so it's not harmonized at the EU level, and the recent study has shown that at least 22 out of 27 member states have adopted or are in the process of adopting this type of legislation. So then we can have multiple decisions by national competition authorities sanctioning the infringement of the DMA obligation vis-à-vis the gatekeepers within their own country, not at the EU level. Will this power be used by national competition authority? Yes or no? I don't know. But clearly, in my view, this is a sort of, it goes against one of the basic rationale of the DMA, which was to prevent member states from having an enforcement of a regulatory framework at the national level. We also have a coordination system. What is the impact of the DMA on competition authority of non-EU countries? I understand that you come from Serbia, if I'm not mistaken. So as at the moment, it does not have an impact, okay? So clearly the Commission decision in terms of designation, those ones about infringements and so on, are applicable. They have a value on the gatekeepers operating within the European Union. Then, what we don't know, because it's up to the gatekeeper, to decide whether and to what extent to modify their business practices also in other non-EU countries. Because clearly for them to comply with the DMA obligations only within the EU, but then to have a different type of service, let's say for Serbia, it's a cost. So it might well be that there is some kind of extraterritorial enforcement of the DMA also on the neighboring European countries outside of the EU. It's still not fully clear to me. It's clear that the gatekeepers have decided, most of them, to not to comply with the DMA obligation, for instance, in Asia or rather than in the United States. So this is very different, for instance, in comparison to the GDPR, which had a much more extraterritorial enforcement than the DMA. Then the question that you are asking is also about what is the future of Article 102 investigations. So if in my previous slides, when I talk about the ongoing cases, I said that only the Commission and the Competition Authority of Italy, France, Germany, and United Kingdom have investigated abuse of dominant cases in digital markets. The other authorities don't even try. Why? Because of what you said. These are extremely complicated cases. We are talking about new theories of harm. We are talking about asymmetry of evidence. We are talking about companies which have deep pockets, which can pay a lot of consultants and lawyers, and we might easily win in court, let's say. So there are very few authorities who really can challenge, let's say, this type of practices from, let's say, a practical point of view. And I have to say that probably this Article 38.7, which gives the possibility for the national authorities to, let's say, sanction breaches of the DMA, even though many authorities will have this power, I doubt that many of them will use it in practices. So it will be more like, as I think your colleague said, Anna said, will be more about supporting the Commission in the investigation rather than what the Bundeskartellamt is doing, adopting its own decision to sanction the gatekeepers in parallel to the Commission decisions. But again, these are speculation because we are talking about a legislation that de facto entered into force last year. Let's move on. So the DMA also includes forms of cooperation between the Commission and the National Competition Authority, which are very similar to what we have under Regulation 1/2003. So there is an exchange of information. I think Sonia mentioned before the high-level working group, which is recently established, which gathers in Brussels, I think twice per year, not only the representatives of the National Competition Authority, but also the telecom and data protection authorities. So it's a first example of a sort of cross-regulatory authority working group, which to some extent accepts the complexity of digital markets and the need, let's say, to have a more holistic approach in this view. Then there is also cooperation with national courts, but I will not go into that for the moment. And I will rather go in, because we are running late, I would like to ask you a second question. So, do you agree with the DMA departure from the traditional antitrust definition of the relevant market and market power? So we said under the DMA it's sufficient to have core platform services, to have a large number of users and capitalization turnover to be designated as gatekeeper. So to some extent, the idea of the DMA is to speed up, let's say, the investigations by the Commission or by National Competition Authority. So what do you think? Yes, the traditional tools of antitrust analysis are not apt to identify competitive pressure in online markets, or no, the digital sector is highly innovative and requires a case-by-case analysis. Who would like to raise the hand for answer number 1? Sonia, you also? Okay. Do you want? Both of them, okay, both of them. Anybody who is strongly for number 2? Also, okay, I see most of you come from competition authority, so you have a rather regulatory approach. Anybody wants to give any comment to motivate the answer? Do you want to say something?
I think 1 and 2 are correct.
Both of them are right. Okay, very interesting. Okay, since we have only 15 minutes left, I would like to move to the enforcement trends. So, as I told you before, the DMA entered into force in November 2022. Then there was a period, let's say, of transition. Afterwards, the gatekeepers had, at least those who fulfilled the thresholds mentioned in Article 3, had 6 months to notify their position. That happened in July 2022, actually, sorry, 2023. In September 2023, the Commission designated the first gatekeepers, which had 6 months of time in order to send a compliance report to the Commission. That happened in March this year. So this is the timeline of the current enforcement. These are the 6 gatekeepers which have been designated so far, plus Booking.com. Booking.com was designated later, only May. Why? Because if you remember under Article 3, you need to have this 40 million number of users over 3 years, okay, to show that you have a stable gatekeeper position. Well, 2 years ago, we had COVID, and the number of users who relied on platforms like Booking.com to find hotels was close to 0. Okay, so to some extent, the Booking.com and other platforms which are active in the sharing economy have not been designated gatekeepers, but this does not imply that they will be designated in the future. So what I wanted to say is that the gatekeeper designation is a dynamic concept. So every 2 years, the Commission will review whether the current designated gatekeeper still have the number of users and capitalization and turnover to be gatekeeper, but it would be possible if the DMA obligations are successful and the markets are open, then the number of users goes down. And I don't know, maybe tomorrow, Google or Meta will not be gatekeepers anymore, will not be subject to this asymmetric regulation. This could be a sign that the DMA was successful in terms of contestability. While we might have new platforms which will raise in terms of number of users and turnover, and they will be designated. The designation is per core platform service. So for instance, if you can see in this list, Google has been designated for several core platform services. So all the core platform services provided by Google, where Google has been designated, are subject to the DMA obligation. While, for instance, the scope of the DMA for TikTok is minimal, let's say, because it has only been designated for one core platform service. Okay, so there is also this aspect. The DMA obligation don't have the same impact on all the gatekeepers because not all the gatekeepers have been designated for the same number of core platform services, let's say. Then here we have some information about the gatekeeper designation analysis. I will not spend a lot of time because in any case, tomorrow, the first panel of the autumn conference will be about this subject. So as I said, the Commission has accepted to some extent the arguments of some gatekeepers which have successfully rebutted the gatekeeper position, saying we fulfill, let's say, the turnover thresholds, but Gmail or Samsung internet browsers, it's really not a gatekeeper position. We also have several cases which have been appealed to court, at the General Court, and then later we'll go to the Court of Justice in terms of designation of the gatekeepers. So far, the only ruling has been the ByteDance versus Commission in July, where the General Court fully upheld the Commission decision. So ByteDance, which is the company providing TikTok, has been designated gatekeeper. So the argument, say, we are a new entrant in the market and so on, have been rejected by the Commission and by the General Court. The other cases about Meta and Apple have been, at the moment, are pending, but I have serious doubts that they will be successful. Then we have the ongoing cases concerning the Commission market investigation and infringement investigation. So this is what the Commission is working at the moment. So forget about the first point because it was actually closed yesterday. So yesterday the Commission closed the market investigation on X, Twitter, which the Commission decided to accept X let's say, argument. So it has not been designated as gatekeeper, while Booking.com, designated in May this year, now has 6 months of time, so until the end of the year, to submit a compliance report to the Commission to explain how it complies with the DMA obligation. Then we have 3 infringement investigations which are pending, which have been opened by the Commission after the compliance report will be submitted in March. So we have the case concerning Meta that we'll discuss tomorrow in the second panel of the conference. So essentially, one of the important, I would say, obligations of the DMA is Article 5.2, which prevents gatekeepers from combining and cross-using personal data collected across the ecosystem. Okay, so Meta cannot combine together data collected from Instagram and Facebook unless it gets the consent of the users. And since last year, basically what Meta started to do is to introduce a new versions of Meta, which is subject to a subscription fee of 13 euros per month. And it has, according to the European Data Protection Board, and the Commission is still thinking about that, this might not be a valid consent. So to ask users, either you pay me or you give me your data, is not a sort of free consent. But we'll talk about that tomorrow. Then we have other two pending investigations about Article 5.4 concerning Apple and Google. The gatekeeper shall allow business users to communicate and to promote their offers to end users. That will be the subject of the third panel tomorrow at the conference. We also, in the third panel, will talk about the new case involving Apple under Article 6.4. The gatekeeper shall allow the installation of third-party apps and app stores. And last, this very last development, which I find very important, is the new case open in September by the Commission on Google. Why this case is important? So it's a case about how, let's say, Apple should ensure interoperability between its services and those of other, let's say, providers of apps that rely on iOS system. Why it's important? From a procedural point of view, it's based on Article 8.2. So unlike the other pending investigation, in this case, the Commission will engage in a regulatory dialogue with the gatekeepers, so with Apple. So rather than imposing fines, here we will have a sort of dialogue between the Commission and Apple. It's a sort of commitment procedure to some extent. So we'll see whether this will be successful or not. Clearly, at any time, the Commission can go back to the classical infringement, let's say, scenario. I think the Commission has accepted this type of procedure because interoperability is very complicated for a technical point of view. So it's difficult to say, okay, you need to comply. No, we need to have a dialogue to understand what does it mean interoperability in practical terms. But it gives a sort of sign, let's say, to all the gatekeepers the Commission is open to negotiate. This specification procedure is only available for the Article 6 and Article 7 obligation, not for Article 5, which are self-executing. So it could be applicable, for instance, to the Apple case concerning Article 6.4, but it will not be applicable in the Meta case, which affects Article 5.2. So we will see what this will lead, let's say, to effective compliance. I come to the conclusion. So we talked today about the DMA, which is probably the first example of in the world, with the exception of Section 19A of the GBB, about sector regulation of digital platforms. Why we have the DMA? There are several reasons, a lot of discussion, probably because we have systemic market failures in the digital markets. Antitrust enforcement is not effective, it's too slow, and there might also be some political reasons behind. What are the basic features? So it's an asymmetric regulation that, like in network industry, only affects large platforms called gatekeepers. And the idea is to open up these markets via a set of positive and negative obligation to strengthen content but also ensure fairness of the gatekeeper practices vis-a-vis business and end users. It's very different from antitrust in terms of enforcement approach because it's based on the idea of notification, very similar to mergers control. is based on an idea of ex-ante obligations, like in economic regulation, that the gatekeeper has to comply, and only in case the gatekeeper does not comply systematically with this obligation, we will have fine. So it's really the last resort. There are a lot of open questions. So will really the DMA shorten the proceedings? We don't know. We saw how many cases have been appealed in court for the designation decision. Clearly, if the Commission now sanctions Apple, Google, and Meta, these cases will go to the court in Luxembourg. The DMA are rigid obligations, so there is no much scope of adjustment of the obligation, taking in consideration the different business law models followed by the different platforms. These obligations are addressed to all the gatekeepers, not per core platform service. You know, there is a lot of rigidity in the DMA. It's very different in comparison to the UK legislation, where the CMA will be able to engage in a sort of dialogue with the platform, which have a significant market power, and introduce sort of ad hoc remedies, let's say. This does not exist in the DMA. Then an open question is also the effectiveness of fines, of remedies, also a relationship with with national law and with competition law. The DMA and competition law are separate. So in theory, the Commission could sanction the same platform, both for breach of Article 102 and for breach of the DMA obligations. Will this happen or not? Personally, I don't think it will happen. So we will have less cases of abuse of dominance, at least for the gatekeepers.
Sonia mentioned that Google Ads. I mean, it was after the DMA entry into force. So I mean,
we will see. Yes, we will see. But this would be very risky for the Commission to go to the court of Luxembourg on this point. And then also, I would say the extraterritorial enforcement, what I think Elena was mentioning before. So will the DMA modify their business practices in line with the DMA obligation only within the European Union, or also, let's say, in other markets outside of the EU? This is also a sort of open question.